Hi, I'm firearms attorney Gilbert Ambler, and today we are going to talk about the injunctions that have been issued against the pistol brace rule, what those injunctions mean, and why the fact that there have been injunctions issued is a very, very positive step for the likelihood that the entire pistol brace rule is going to ultimately be struck down. Before we dive into it, if you have not yet hit that subscribe button, go ahead, hit subscribe, like this, comment, share this. That way you and your friends can keep getting this important Second Amendment related content. All right, we need to understand what an injunction means, especially what a preliminary injunction means here, because ultimately we want this rule to be declared permanently unconstitutional and permanently enjoined. But right now what we're dealing with is preliminary injunctions, okay? A preliminary injunction occurs prior to a full trial. It means that a judge has not yet seen and not yet heard all of the evidence in a case, but has been asked to make a ruling to stop something from going into effect, to make sure that essentially the parties aren't further harmed while we wait for trial. Because as we know, when we talk about civil litigation, it can be a very long, very time-consuming process to actually get a case through trial. And often, judges are asked to stop something prior to trial to make sure that a party is not irreparably harmed. Okay, now that term, irreparable harm, is one of the four things that a plaintiff needs to show in order to get a preliminary injunction. In order to get a preliminary injunction, the court is going to evaluate, number one, whether there is irreparable harm, number two, whether there is a likelihood of success on the merits, number three, the balance of hardships, and number four, whether an injunction would serve the public interest. Okay? Now, in these cases, the judges are tasked, and there's been several judges in the Fifth Circuit that have granted injunctions for the three major gun groups that sued: Gun Owners of America, Firearms Policy Coalition, and Second Amendment Foundation. All three gun groups have gotten preliminary injunctions, which means that a judge has found that they met this legal test. Let's go through this test so that we understand exactly what this test means and how it is applied. We're going to start with the easy factors first, okay? The easy factor is going to be whether the injunction weighs in the public interest and the balance of hardships. And when the government is the opposing party, these two tests largely merge. And when there are constitutional rights at stake, this becomes an easy argument that the balance of hardships weighs in the favor of the plaintiff. Because if constitutional rights are being trampled upon, it is always in the public interest to protect those constitutional rights. So the judge is looking at these cases when there's a constitutional argument, say, if it looks like that constitutional argument has merit, then it's going to go in favor of the plaintiffs, because the balance of hardships goes in favor of constitutional rights, and the public has an interest in making sure constitutional rights are protected. The more difficult factors for a judge to get past are going to be irreparable harm and a likelihood of success on the merits. Okay, when we talk about irreparable harm, what we're looking for is non-economic harm. Essentially, the court says non-economic harm is the type of harm that is irreparable. If it is the type of harm that could be fixed simply by one side paying the other side, that is typically not going to be considered irreparable harm. Again, constitutional rights factor in here, because with constitutional rights at stake, the payment of money from one side to another is not how we would fix those violations typically. So, because there are constitutional rights hanging in the balance, the judges are able to look at this and say, if we believe constitutional rights are being infringed upon, then we can find irreparable harm. And there is case law out there that says even the temporary deprivation of a constitutional right constitutes irreparable harm. So I think that was strongly in favor of the plaintiffs when they were moving for injunctions on the pistol brace rule. Finally, we need to talk about a likelihood of success on the merits, because this is the factor that not only is the most promising factor when we look at the likelihood that this rule is going to last long term, because in order to enjoin it preliminarily, a judge had to say, we believe that this rule will likely be struck down, that this rule likely will not last. All right? The judges had to find that when this rule actually goes to trial, they believe it very likely that the plaintiffs, those gun groups that sued, are going to win and not the ATF. So that's very, very good that right now multiple judges in the Fifth Circuit have looked at this pistol brace rule and have decided, we don't think that this rule is constitutional. We don't think this rule is going to hold up long term when it actually goes to trial. So what are the next steps? Because if you are a member of one of these groups, you probably breathed a sigh of relief saying, hey, got an injunction in place, I can keep my brace for now. Well, it's been expedited briefing, so there's briefs coming. The briefs are going to be due throughout June of 2023. Argument is set in the Fifth Circuit Court of Appeals on 6/29. Now, does that mean that the injunction will end one way or the other on 6/29? Probably not. It's probably going to be at least several weeks, if not months, after argument is held before we get a final decision on the merits. And of course, this thing might be appealed one way or another. There might be what's called interlocutory appeals, which means appeals before a final appeal on the merit that might go up and down through the various courts. Ultimately, though, it is moving forwards. The briefing is moving forwards. The arguments are moving forwards. And it is a good thing that there are injunctions in place right now protecting many of the people that possess brace pistols so that they can continue possessing these brace pistols as we wait for a final trial on these issues. A final note for those that possess brace pistols: there's been lots of back and forth about the scope of the injunction, whether the injunction covers members of the various gun groups that are outside of the Fifth Circuit. Certainly all of the gun groups have taken the position that yes, it does. And assuming it does, there's a secondary question, which is, who has the burden of proof? If you're out at a shooting range, you've got your brace pistol out at the shooting range, you're shooting it, and an ATF agent stops by and says, hey, that's an SBR, do you have your documentation for the SBR? And you're a member of GOA or FPC or 2AF, do you have to prove your membership in order to avoid getting arrested? And unfortunately, I think that's still an open question. I think it's very, very likely that at that point, officer coming into contact with you could arrest you, and it may serve as a defense for you to show that you are a member of one of these organizations. What none of the organizations will be doing, however, is publicly releasing their roles. So at least Gun Owners of America has committed to not releasing the roles of its members so that no government agent can go look up and see through the roles whether you are a GOA member. And of course, they want to protect the privacy of their members, and I suspect all of the gun rights groups will follow GOA's lead in that respect, where they won't publicly release their membership lists. If you enjoyed this content, go ahead, hit like, hit subscribe. Until next time.